Good morning, everybody.
Morning.
Thank you for joining us today. I see that we still have some people joining, but in the sake of time, we're going to get started. It is probably fair to say that in early 2020, most companies had a clear understanding of their business footprint. Fast forward 2 to 3 months, a global pandemic hits, a nationwide shelter-in-place order is issued, which has caused many employees to work in locations that were probably outside of their company's original business footprints. With everything going on today, you may not think that is a big deal, but that may not be the case, which leads us to the topic of conversation for today. On behalf of Berdon LLP, I would like to welcome all of you to the second of 2 webinars focused on how the COVID-19 pandemic has impacted state and local taxation. Today's area of focus will be how COVID has impacted state and local taxes as it relates to businesses. If you missed part 1, which took place earlier this week on Tuesday and focused on individuals, a recording will be available on our website, www.berdonllp.com, mid to late next week. So please check that out or email myself or any one of your Berdon contacts to get access later next week. Before we begin, I would like to briefly introduce our 2 panelists. With us this morning are Wayne Berkowitz and Richard Goldstein. Wayne and Rich are co-leaders of Berdon State and Local Tax Practice, which advises individuals and businesses on the tax requirements of governments and municipalities throughout the United States. Leveraging their extensive experience, they advise a variety of businesses across a wide range of industries, planning their tax strategies, assisting them in resolving controversies, and representing them in state tax audits. Welcome, Rich and Wayne. Thanks for joining us today.
Thanks for coming, everybody.
How has this pandemic and what is taking place impacted businesses from a state and local tax perspective?
Well, I think it's affected everybody enormously. It's amazing that a lot of businesses have even been able to function. I know here at Berdon, we've been doing great with the Zoom meetings. We'll be able to function. We have access to all of our resources, which is a great thing. Meetings all the time. We've been going so well that we've even had story time for children of the of our employees, because we want to give people a break and we want to keep that connection with all the employees and their children. And they've been reading such great books like The Rainbow Fish, Is Your Mama a Llama? And if you wanted to join us for this week's, I think we're reading excerpts from the new John Bolton book. So the children should be very entertained by that. I'm sorry, I had to get that joke out. But seriously, there really are a lot of state tax issues that come up here. And really they revolve around Nexus, which is where you're doing business, where do you have a tax filing or collection obligation, and also apportionment, which is where is your state tax obligation going to be spread? How is that going to be distributed amongst the states? And we're going to start with Nexus, and we're going to get into apportionment a little bit afterwards. And again, we encourage questions during the presentation. Now, several of the main principles of Nexus, and it's been evolving greatly lately. There's PL 86-272, which a lot of people always come to us and say, aren't I protected by PL 86-272? Well, maybe. That was a law that was passed back, I think, late 50s, maybe 1959, when the world was very simple and we had lots of manufacturing businesses in the US, and you sent out your salespeople. And what Public Law 86-272 said was that for the sale of tangible personal property only, the fact that you have a person in the state that does not go beyond soliciting sales, and you could fill up a room with the cases that talk about what soliciting sales means, that you won't have a corporate tax obligation. Crucial thing to note, and this leads into what Rich is going to pick up on next, is that PL 86-272 has no application to personal income tax and has no application to the sales tax, Rich. And I think Wayfair, which you're going to get into a little bit now, really talks about what's been happening with the sales tax and possibly the income tax applications of Wayfair as well.
All right, thanks, Wayne. I think just to give a little bit more context, we're talking about right now. We're talking about Nexus, which basically means under what circumstances can a state or locality have the jurisdiction to require the business to file tax returns, to collect taxes, to pay taxes? And so we need to understand that up front, what are the basics of that? And then a little later, we're going to take a look at, well, how has the change in telecommuting, or the surge in telecommuting, having people working in different states, how does that impact these Nexus issues? So going back to sales tax, in 2018, a Supreme Court decision, South Dakota versus Wayfair. Wayfair was an online furniture store that sells furniture online, and they were challenging a statute in South Dakota that said that if you have more than $100,000 in sales or 200 transactions in the last 12 months, even if you don't have a single person or any property in the state, all you're doing is taking online orders and then shipping them in by common carrier, you need to collect sales tax. And that was a big onus on a lot of companies, that until that point, they wouldn't have any requirement to collect sales tax unless they had an employee in the state, right? Or they had a property in the state, or they had an office in the state. So presently, the way it works for sales tax is all these states have sort of piled on, and they've all put in certain guidelines very similar to that. For example, in New York State, if you may not have anybody working in the state of New York, but if you sell to people in the tangible personal property in excess of $500,000 and more than 100 transactions, you have to register for sales tax, collect sales tax, and pay sales tax. So those are Nexus standards for sales tax. And there's other taxes as well. There's, for example, Wayne is going to discuss the current Nexus standards and payment standards for unemployment insurance tax.
Well, when this all first happened, I was getting a lot of calls from clients saying, where should I register for payroll withholding now? Where should I be paying unemployment insurance? And I told everyone to take a deep breath, that there's really no guidance out yet, and don't run to register everywhere just yet. And the states have been coming out with some guidance in trips and drabs, as you'll see. But as far as unemployment insurance, I don't know that if you follow that the main factors and the criteria, I don't know that things are going to change much for most people, because there's 4 tests that you go through, 4 hierarchies more than tests. The first thing that they look at is a state of localization. So that means if you're a business that's located in, say, New York, but you have an employee that only works in New Jersey and always only worked in New Jersey and didn't travel to see clients, the state of localization is the first test. You're going to pay unemployment in New Jersey for that person. That's the only place they are. They never come into the office, okay? So that's the first hierarchy. If that won't apply to you or your situation, next thing you're going to look at is the employer's base of operations. So under those facts, you're in New York. The employee comes into New York. Maybe he goes to New Jersey as well. Maybe he travels everywhere. The state of unemployment insurance in that case is going to be New York. The next test after that is the location and direction and control of the employee. So that also can apply if you have a person that's traveling all over the country. And again, the main office is in New York. The last criteria you look at, and you only look to this if the other ones really haven't satisfied your answer, where you're going to pay the state unemployment insurance, is the employee's place of residence. So just because they're working at home now, and they may be working home for the next 6 months, unless that's going to become absolutely permanent, the unemployment insurance obligation really shouldn't change. So those are the factors that you need to go through, the tests that you need to go through, and where the employee lives, is the last of the steps, if none of these other ones make any sense under your facts. Rich?
Interesting. So based on all of this, I'm presuming that states will be requiring employers to withhold personal income taxes on behalf of their employees, correct? And if yes, how will employer withholding requirements differ among the different states?
I think we have a really good slide on this map.
Mm-hmm.
There we go. There we go. Okay, so we've got a sort of a color-coded map here. On the green side, we have what we call relatively friendly states, and on the deeper, I guess, purplish. I'm a little colorblind, but I'll call it purple. Maybe I'm right. Maybe I'm wrong. We have unfriendly states. So what does it mean to be an unfriendly state? It means that in states like Colorado, Indiana, Maryland, Michigan, if you are a business and you're not located in that, you're just not located in that state. You might have some customers in that state, but you're not located. If you have an employee who works there just even one day, under their rules, you can argue about the constitutionality of it, but under their rules anyway, you are required to register to withhold in that state income taxes in that state. And so that's pretty extreme. And, as we start to think about telecommuting and where we may now have employees that we did not have them previously, for example, if you were to take a look at, say Colorado, you have somebody, you don't have an office in Colorado. You don't have employees normally in Colorado. You don't have any property in Colorado. And so let's assume for the moment that now you have someone working from their home for the last 3 months. Okay, unless Colorado will change their policy on withholding, you've pretty much now have another withholding obligation. So you look at other states like on the say the green side, the friendly states, Arizona is more. You have to have an employee in there for more than 60 days before you're obligated to start withholding on them. So but even at this point, we've already been, locked down for over 3 months. So even there, you're venturing into that period where you may already have withholding obligations. I want to preface preface of the opposite. I want to comment on what I just said to say that the policies regarding how much states are going to require and under what circumstances states are going to require employers to start withholding is developing almost daily, and so this is something we're going to be paying very, very close attention to over the next months or so.
And it's not really a new issue. It's just magnified now with the increase in telecommuting. For example, this has been the curse of law firms everywhere. Is you send people in for a case for 2 weeks, 3 weeks, 4 weeks, and you have to withhold if they're non-partner. And how do you withhold, and when do you start? And law firms and accounting firms, especially law firms, have been the target. Years ago, New Jersey was the leader in this. They'd go to the New Jersey courts, look at the pro hac vice admission lists, see who was admitted for a case, and they would go after these firms and say, hey, you didn't withhold. So what do you do if you have someone come in for a trade show? What do you do if you have someone working on a job for 2 weeks? So these have always been thorny state and local tax issues that are now just being magnified by the pandemic and the and people working from home. So these issues have been there a long time.
If I can, Wayne, I'd just like to point out that even in a state like New Jersey, which might have, for example, an economic nexus standard, where even if you don't have anybody in there, if you exceed a certain threshold of receipts, you might need to start filing returns there of different sorts. maybe withholding, maybe corporate income. But the bottom line is, if you have a physical presence there, right? This firm, let's say this law firm that sends someone in there pro hac vici, now actually has an employee working there, whether they've exceeded some sort of minimum financial economic nexus. They have nexus, period.
Correct.
Barring some change in policy, and New Jersey has stated some policy changes with respect to nexus, and we can talk about that in a bit.
I know. Even prior to COVID, neighboring states in certain areas of the country have agreements in place that eliminate the issue you guys were discussing. So based on our audience, it may not be an issue if they're outside of their normal business footprint, if there is some type of agreement, right? So how does that work? And for all the local folks in the audience or on the webinar, where does the New York tri-state area stand with regards to these types of agreements?
Well, I think we have a slide on the reciprocal tax agreements, the first slide. And it really depends. If we could just put that slide up, that would be great. And, the reciprocal tax agreements allow a resident who works in one state and lives in one state, works in a neighboring state, to only have withholding done in one state. It avoids the messy issue of tax credits. So, we like to see those being in place. Unfortunately, enough states really haven't done those, Rich. So, you still need to kind of be on top of it.
Yeah. So like you can see in this particular area, what we're showing is New Jersey and Pennsylvania have a reciprocal agreement in place. So, and it's based on residency. So the withholding is not based on the state in which you're working, but it's based on the state in which you are a resident. So if you're working in Pennsylvania, but you reside in New Jersey, the default withholding should be to New Jersey. And as Wayne pointed out, it does, avoid the issue of a state having to provide a income tax credit to its resident for taxes that would, in this case, be paid in Pennsylvania. So it's a cleaner way of dealing with the issue. Unfortunately, New York, New Jersey, Connecticut, So you're into a credit system where if you reside in a state, hopefully that state will calculate a credit for you for taxes paid in the other state where you work and paid taxes that is sufficient to cover those taxes, so you're not paying tax on the same income 2 times. So basically what I to sort of sum it up, the way these reciprocal agreements are is that if you have an employee in a state and he lives in another state, if there's a reciprocal agreement, generally the withholding requirement defaults to the state of residency and not to the state where the person is working.
Now, just one thing I wanted to cover and go over. We had mentioned this in our presentation on Tuesday, for those of you that attended, just to add insult to injury in the New York tri-state area. New York has what's called the convenience of the employer rule, and this doesn't affect the employer's withholding obligation, but it could hurt your employees potentially. New York essentially has this rule, and Connecticut has a modified version of it, and maybe 3 other states have it. Most states don't. So if you're employed by a New York employer, and that's where you normally work, the fact that you work at home now in another state, New York doesn't care, and they're still going to try to source that income to New York State. So, for example, the classic example of that was Professor Zelinsky, was a law professor at Cardozo Law School in New York City, lived in Connecticut, spent about half of his time working in the city at the school, the other half of his time at home grading papers. Professor Zelinsky, which made sense, allocated 1/2 of his wages to New York State, and 1/2 of his wages to Connecticut. New York came back and said, no, sorry, we want all the wages. Okay, it wouldn't seem so bad. You would think he'd get a credit in Connecticut. No, because Connecticut said the time that you spent working in Connecticut, that's Connecticut source, and we're not going to give you credit for Connecticut source just because New York has this ridiculous rule. And essentially he ended up paying tax twice on half of his wages, and the highest court in New York upheld that. So that's something that needs to be watched out for and can be planned for, but it's going to create some problems with the telecommuting.
You know, it's interesting. In one way that the courts justified upholding the work-at-home rule is a shorthand version of that is to say that it doesn't interfere with it's not a burden on interstate commerce, because a school like, for example, Cardozo in that example has no nexus with the state of Connecticut, and therefore, if this person is living in Connecticut, their income that they're generating from Cardozo is not Connecticut source, because it results from Cardozo University Law School, which is in business in New York, and so therefore it's New York source. That's sort of the shorthand version of how this thing gets justified, but it is a very difficult and unfortunate rule.
It is. Good, Rich.
Another thing I'd like to point out is that, we're talking about, normally what we'd like to see is that the obligations for withholding on the employer and the obligations for paying tax at the employee would match. That's ideally what we would like to see, which is why the states with reciprocal agreements make this whole thing flawless. But we don't always end up in that situation. You could easily end up in a situation where an employer might not be required to withhold, and yet the employee is obligated to pay tax. But we always have to look at it from both lenses. What is the employer's obligation, so that the employer itself is in compliance with the withholding tax laws? That's a separate issue from the individual's obligation, making sure that the individual is in compliance with their individual tax obligations. So always important to make sure you're looking at it from two different perspectives.
And just also, for example, it's important there, and we could help people with planning. We do this all the time. For ourselves, for the firm, we have some employees who, before the pandemic started, wanted to work from home or even from a state on the other side of the country for various reasons. And we were very actively involved in helping draft their agreements and explain to them we were doing this for their benefit, certain conditions in the agreement, so they wouldn't end up being taxed twice on their wages. And we spent a good amount of time going through that with them, but it's important to plan that out, and it's for their own benefit, because as far as withholding, it didn't affect the firm one bit, but we wanted to make sure our employees weren't hurt for doing this.
And Rich, we did get a question. They asked, someone asked if we could elaborate on how the convenience of employer rule will affect Connecticut residents who work for New York firms and are working from home in Connecticut.
What's going to happen is that New York, in theory, could say that your wages are all New York source because you're working for a New York employer. Connecticut's going to say, no, we just look to where the work was done, so it's our source. Being a resident of Connecticut, you're taxed on your worldwide income, and you normally get an offsetting credit for the wages taxed by the other state that is sourced to the other state. The problem is that New York's going to say it's all our source. Connecticut is going to say, no, the portion that you worked at home is Connecticut's source, so therefore you don't get a credit for that. So you have New York taxing potentially 100% of the wages. You've got Connecticut taxing the portion for at home, and you're not getting a credit. So you would end up being taxed twice on all or part of the wages. I have some arguments in mind to get around that. One of the things for the convenience rule is that the employer, it doesn't provide you with an office space. I'm thinking the argument's going to be, Rich, that if you're mandated to not be there, that they didn't provide you with space. So possibly that's a way that we're going to be able to combat New York if they get aggressive on the convenience rule?
Yeah, let's be clear. We're talking about this COVID-19 situation, and obviously the ramifications, their future ramifications. But during this period in time, I anticipate, although New York has not said anything about this, I anticipate that they will be realistic during this period of time and understand.
We hope.
Interpret this as not being, this working from home in Connecticut as not being the convenience of the employee, but rather being the requirement of the employer, because the employer is shut down. They're not allowed to use their office, and therefore they need you to work at home. To me, that seems like the only reasonable conclusion here. But then again, the tax departments are not always reasonable, and I would imagine if they take a harder line approach on that, there certainly will be instances that will result in litigation, tax litigation. I suspect that won't. I don't think it'll take that turn, though. I think New York, although they haven't commented yet, I would be surprised if they take such a hard-nosed approach on this one.
So I know we had some case studies to kind of emphasize these reciprocal states and agreements. So why don't we get into those a little bit? So the first one, for example, our hypothetical: my business is based in my business is based in Virginia with offices in Maryland. My employee is a Virginia resident and generally works in the Maryland office, but is teleworking in Virginia due to the pandemic. Do I, as an employer, have a Maryland withholding requirement?
Wayne, are you going to take that?
Sure. Well, essentially, no, you don't. I mean, your employees, are not Maryland residents. They're not performing services in that state. And fortunately, even if they were providing services in the state, Maryland has a reciprocal agreement with Virginia, which would kind of take care of that for you. So in that case, it should be smooth sailing, I believe.
Okay. Let's go to the next one. In this example, my business is based in Delaware with an office in Maryland. My employee resides in Delaware, but generally works in the Maryland office. The employee is currently teleworking in Delaware. Do I have a Maryland withholding requirement?
So in this situation, I would assume they're teleworking again in Delaware at one of their home locations due to COVID. And so there is no reciprocal withholding agreement between Delaware and Maryland. And so there is going to be a withholding agreement in Maryland because the individual is in fact working telecommuting from Maryland. So it's Maryland source income, and the fact that the person is a Delaware resident is not going to in any way help you avoid Maryland withholding on this particular employee.
Okay. Now for our final example. My business is based in Delaware with an office in Maryland. My employee resides in Delaware, but generally works in Maryland office. The employee is teleworking in Maryland this time. Now, do I have a Maryland withholding requirement?
Well, the answer is yes. I mean, again, Delaware and Maryland don't have a reciprocal agreement, and it's based where the work is done. You have a withholding requirement, for the compensation for services rendered in the location where they were done, and so that's exactly what's going to happen is that you are going to have to withhold that.
Wayne and Rich, have state and local governments issued any guidance or relief on filing requirements for businesses that have employees working from home in different states? If so, what has that guidance been and what has come out?
Well, fortunately, states have provided a guidance. Not all states, but
some.
And as we're going, as I said earlier, this is going to be a work in progress. Weeks, months, we're going to see more and more relief. Some states have issued guidance aimed at maintaining the status quo ante. In other words, sort of like if you were obligated to withhold in a particular state prior to that on a particular employee, don't change anything. Just keep withholding, even if they're not working. Other states have come out and said quite the opposite. So, what we have is a big puzzle here, and everybody's going to be different. And so you're going to have to look at where your employees are currently telecommuting, and then you're going to have to look at the policies. And here's a few examples for example, New Jersey has come out and offered relief from corporate tax nexus and sales tax nexus. So that meaning that just because you have an employee, normally having an employee in the state, automatically, I apologize, automatically causes nexus. And that's not the case during this state of emergency for sales tax purposes as well.
So if you didn't have Nexus before, and the only thing that changed is
Exactly.
you have someone telecommuting in the state, they're not going to grab you for that.
Right.
Is that a fair way to put it?
That's a fair way. It's basically if the sole reason that you would have Nexus in the state is because of that particular telecommuting employee, but for that particular telecommuting employee, you would not have Nexus. You don't have Nexus, at least during the period of the state of emergency.
And I think New Jersey even said that they're not going to make you withhold for this work done there.
So Rich, you just said as long, during the state of emergency. So as states start opening up and businesses make decisions, and some businesses decide to go back to work, and some businesses don't decide to open or give their employees the option, that might change, because if the state of the emergency is lifted and it's now the employer's choice to give the option to telework, is that kind of the gist of what you just said?
Well, I think it definitely presents people are going to have to stay on top of this. If it's the employee's option, but the employer is able to open the office so that the individual does not have to telecommute. They can, for example, come back to New York. They don't have to work from their home in New Jersey. I think some states have actually indicated if you were to get a doctor's note, you may be able to avoid sourcing that income to New Jersey. Do you then turn around and give that doctor's note to your employer so they can avoid withholding? This is so interesting and so complicated and so cutting edge that we are going to be reviewing the particulars of what states are doing policy-wise. There hasn't really been much in the way of legislation at the state level like there has been federally. It's, Frank, that's just a great question, and it'll have to be addressed on a state-by-state basis until there are some we have some rules that we can rely on.
I'm sorry to throw the wrench in there, but we know this is an ever-changing situation that we're all finding ourselves in, and it's an unprecedented one. So I'm sure there's going to be continued change. But why don't we continue with some of the things that have come out from some of those states? Because I know you have some other examples that you wanted to share.
Yeah.
Just one other thing. A lot of these rules are garnered through governor's press conferences, state tax announcements, not necessarily rules, regulations, and statutes. So it gets even fuzzier. But anyway, Rich, let's go through some of the states.
Pennsylvania has also offered sales tax and corporate income tax nexus relief, similar to New Jersey. In other words, if the only reason you would have nexus now is because you have a telecommuter working there during the course of the emergency, but for that, having that person there, you will have no nexus. Then you have no nexus during the period of this emergency. But interestingly enough, they've said that if you have an employee who habitually or his primary office is in Pennsylvania, and that person is non-resident of Pennsylvania, is currently not working at that office because that office is closed, right? So they're working from home outside Pennsylvania. They have said they're going to give the company a break. The break is you don't have to do anything; just keep withholding in Pennsylvania. And interesting, is that are they doing anybody any favors? I don't know. Maybe I guess it depends how you look at it. It's less paperwork. What does that mean for the employee down the road? Well, we'll see. Connecticut has offered no guidance. New York has offered no guidance. Illinois has said that if penalties, they're willing to waive. So if they're willing to waive,
this is very generous
for failure to withhold on telecommuters who are working from their home in Illinois. So we know their position is if you're telecommuting in Illinois, then even though you normally don't work in Illinois, they want the employer to withhold, but they'll abate penalties, I think, within a certain period of time. You have to look at the particulars of that particular penalty abatement relief.
Mm-hmm.
We're not prepared to really discuss that on this forum. But
just an observation, Rich. So Illinois was one of the very friendly states when it came to just withholding rules in general. So do you think that map, that colored map, that those trends of who was friendly prior to COVID are going to be more friendly during COVID?
Well, let's take a look at this. There's certain things that are, statutory, right? To the extent that the thresholds for withholding are statutory or even regulatory, there's not that much room for change. This tax department, particularly if it's statutory, but the tax department does have room to set policies on enforcement. So I would say that to the greater, I think I would use this as the predictor, the greater the economic hardship the state is under, the more likely they are going to find Nexus and require withholding and income taxes and apportionment and all that good stuff. I think it'll be tied directly to the financial situation of the state.
Mm-hmm. That said, some of the other states out there, Florida has no guidance. Obviously, there's no withholding, there's no personal income tax, but they haven't addressed it, for the sales tax or for the corporate income tax. Georgia's done similar to, New Jersey. Essentially, they're going to waive Nexus if it's solely based on somebody being in that state. Massachusetts really has done the most, I think, of any state, Rich, where they actually issued emergency regulations, which I think that's the only state I've seen actually do that, a little bit more formally. And they're saying that corporate income and sales tax Nexus is going to be waived from having a telecommuter in the state. Maryland, I think, affirmatively has come out and said they aren't going to give any relief from Nexus for this. And Rhode Island waived corporate and sales tax Nexus, and the withholding they're saying isn't changing. South Carolina has also provided some relief, and they're going to say keep withholding as you did before, which could be helpful or harmful. And I think that brings us to...
And I believe Massachusetts, going back to Massachusetts, did something else that was pretty interesting. I believe they said that if, as a result of COVID-19, the state that you work in, a state other than Massachusetts, so you live in Massachusetts, but state other than Massachusetts, if that state is requiring you to pay income taxes during this period, even you're locked down in that state, perhaps. Massachusetts has said that they're going to be liberal in allowing their resident credit under those circumstances. So even if technically the income might not be sourced to that other state, and maybe Massachusetts rightfully has a claim to tax that income of the employee, Massachusetts has indicated that they will take cognizance of the fact that the other state is taxing the income. Like for example, Pennsylvania says you're not working here, but because you used to work here, you still have to pay tax here. Massachusetts, in a situation like that, is going to be inclined to give a tax credit to its residents. So that's a nice thing.
So we do have a question from the audience, and it's a more local question about New York City. They asked if we could speak about the impact of all of this on the New York City UBT, the unincorporated business tax.
We can. That's an interesting question, which is going to lead into one of our next topics, actually, also, which deals with cost of performance versus market-based sourcing for receipts factor. We'll get into a little bit more detail on that, but cost of performance looks to where the services are actually done. The New York City UBT still looks to, I'm going to go over this quickly because we're going to get into some more detail, but the New York City UBT for receipts for services still looks to cost of performance, even though the New York City corporate tax doesn't. So technically speaking, if you don't have your employees coming into the city to perform services and they're performing them elsewhere, Long Island, Westchester, any place else, the cost of performance is no longer going to be in New York City, and arguably you can have a much lower New York City apportionment factor and a much lower New York City UBT. And I think that's certainly a valid position to take, and it's probably the right answer. And
Right.
I could probably guess who's asking this question, or where they work, or where what they do. A lot of clients have been asking this, especially in the professional services area.
I'm going to guess it's an unincorporated business that
In the
works
professional
in New York
services
City.
field. Mm-hmm.
So yeah, it's we are going to head into that area shortly.
So just, to sum up, with regards to all the different relief being issued by the different states, it seems like it's an evolving situation. If anybody in the audience has any specific questions that we're not addressing right now, please feel free to submit that question, and we'll address it after the webinar, or we'll connect you directly with Wayne and Richard to help address those questions, because this is continuing to change. We also do advise that you continue to identify or look to the states where your employees are working to see what's coming out in the coming days and months as this continues to move forward. But let's move on to that topic of apportionment. You mentioned earlier that it is an issue, and you just mentioned in that question from the audience. How is telecommuting during the pandemic impacting income tax apportionment?
Right. So as you noted, we were talking about just the UBT before, and the apportionment rules, and how radically the COVID emergency might change the tax liability for unincorporated business taxes. So that's a very specific issue, UBT tax, but it's related to the bigger picture, which is apportionment. How do businesses decide, or how do states decide what part of a business's income belongs to them from a tax perspective, right? Because you've got businesses, whether they're partnerships or corporations or sole proprietors, operating in potentially 50 different states, right? So each state gets some of that income to tax potentially. Traditionally, it's done by three-factor apportionment, which is a formula. It's a percentage. You take a look at your wages paid in a state, that's a denominator, and you figure out how much of those wages belong to employees working in the state. And then you take your receipts in a denominator, and in the numerator you put in the receipts that were earned in that state. And then property, what kind of property do you have everywhere? And in the numerator, you multiply those, you do the division, you add it up, and you come up with a percentage, and you multiply your net income times that number. And that's how much that particular state is entitled to tax. And then more recently, we've been heading, and I think we have a slide on this, to single sales factor representation. We forget about the payroll factor. We forget about the property factor. And you can see, if we're looking at C corporations, and by the way, many partnerships use the same rules as a C corporation.
And you also need to be aware, that many states don't use the same. So one state may have one rule for corps and have a different rule for partnerships and LLCs. So you just need to be very aware of that as well.
Now, in a state that uses 3-factor and still has a wage factor, how would COVID-19 impact that? Well, as I had said before, you're coming up with a fraction to apportion income, and the denominator is your wages everywhere, and your numerator is your wages inside the state. So how do you decide what wages are in the state? So there's 2 basic ways. Some states, and some will say, an employee is located and the wages for that employee are in our state if the person is primarily based in an office in our state, okay? The second rule is, it doesn't matter where the employee is based, what state they're based in. What matters is where they're doing the work, cost of performance. So that brings in the COVID-19 issue, which is where, so if, for example, you have an employee who is based, for example, in New York, but is presently not working in New York, they're working somewhere else from their home. In a state like New York were to be using, for example, if they were in the partnership level, they would be using a payroll factor. But let's just say they use a payroll factor. If you're using an office-based, those wages are still going to be apportioned to New York. And New York's a bad example, but the principle is the same. It's that it doesn't matter where the person is working. What matters is what office they're assigned to. Conversely, if you have a state that looks at where the employee is doing the work, cost of performance, then it doesn't matter what their primary office is. So during COVID-19, those wages are going to be considered wages working from the person's telecommuting location.
Where this is really going to mess people up is with the fact that there's a single sales factor now, and the cost of performance versus customer benefit and market-based sourcing. And just as a way of background, the reason that states switched to single factor was really a way to compete with each other, saying that you could have as many employees here as you want, have as many offices and facilities here as you want, and there's going to be no penalty here. We're actually encouraging you to do that. So it brings jobs to the state, it brings building to the state, and it's going to have people paying, property taxes and sales taxes, and possibly payroll withholding taxes. But it's going to help it's going to lower the corporate tax base. So there's no penalty for you corporation or any other type of business to locate in our state. There's no headquarters penalty for being here, and bring as many as employees as you want here. But now that it's single factor, the way receipts are sourced for tangible personal property these days, it's easy. It's where the goods are shipped. A simple version. I know there's some exceptions where title passes, with trucks, almost all that's gone anyway. But today, if you're shipping tangible personal property from New York to Georgia, that's going to be a Georgia sale. Okay, I'm sure there's some exceptions to that, but the main point is this: services. The trend is towards the cost of performance, as you could see in our slide. That's the trend. So the trend is towards market-based sourcing, where the customer is receiving the benefit. Cost of performance is more the traditional rule. Where is the person doing the work? So if you're a law firm and someone's now home working, in New Jersey, but the case is in Oklahoma, how do you source that? Well, you know what? If the case is in an Oklahoma court, don't remember what Oklahoma's rule is offhand, but if they have where the customer receives the benefit type sourcing, Oklahoma's going to say it's an Oklahoma receipt, and where they're doing the services, if that state says it's cost of performance, they're going to say source it there, and there's potential conflict. Now with COVID and people working in different places, this could have a significant impact still on the cost of performance sourcing states.
Yeah,
Rich,
so yeah, just to emphasize, I think the last point is really, really important, which is that, so for states, right now we're talking about states that use single sales factor apportionment. Basically, they take all your sales everywhere, put them in a denominator, and then you try and figure out what goes in the numerator, that denominator, and that's your percentage of sales that get allocated to a state. So the point is that market-based sourcing is very different than cost-based sourcing in the numerator. So if it's cost-based sourcing, then where you are working, and obviously during a telecommuting period because of COVID, where you are working may very well be your home. It may very well be different than under normal circumstances, which might be normally maybe you're working from your office in another state. That's going to change where the receipts get allocated to. And so we're going to have to pay really close attention to that during 2020 to make sure that we are allocating our receipts accordingly in states that use cost of performance to source receipts. In states that use market-based methodologies for sourcing receipts, this telecommuting issue is not really that relevant, because we don't care where the work's done. We care where the market is, or another way of saying it is, where did your customer receive the benefit of the service? And to bring back Wayne's example, typically they'll say, let's say there's a litigation issue involving real property. Well, if the real property is in Iowa, then even if, let's say, the court is in another state for some reason and the lawyers are in other states, well, the benefit generally would be in Iowa because the property is in Iowa. So, and where the lawyer does the work, whether they're sitting at home telecommuting or in the office or in Iowa, is irrelevant. It's where the benefit is received. So cost of performance states, be careful. It's going to be tricky this year because of COVID and telecommuting.
So we do have a question from the audience. What happens to an employee who is a New York City resident but relocates due to COVID to another state and files New York State non-resident forms? What should the employer do in that situation?
That's a very complicated question. I'm going to tell you why. The employer, if the employer is going to stop withholding, he needs to get the verification on the proper withholding forms from the employee, and the employer is entitled to accept those in good faith. Rich, you agree with that? For withholding, but as far as their residency, just because that employee picked up and went somewhere else doesn't mean they change their residence, and that's their problem. But from an employer's perspective, you're allowed to accept the exemption from withholding forms in good faith.
Yeah, but good faith is the key. So if it's a small
Exactly.
business and you know better, it's not going to. So let's be clear about this. When it comes to withholding, there's a company has liability.
Correct.
If they fail to withhold properly, and the individual does not pay their taxes, the employer can become liable.
But as an employer, you're not required to do a residency order for them.
You're not required, but again, smaller businesses.
But even technically, even if that person pays the taxes, the penalty technically, and I've never had this imposed, is 100% of the tax anyway.
Yeah,
so you could still be liable even if the employee pays it.
Right. And there's another issue about this that I'd like to address, which we addressed earlier, which is even if the person up and leaves and becomes a non-resident, if the only office or if the primary office is still New York, for example, and this person is now working from home because there is no office in the state where they're working, even though they're filing a non-resident return, those under New York's rules, those those wages will still be allocable to New York on the non-resident income tax return, because again, this presupposes that there is no office where the person in the state the person's working from, and they're working from home in that state, and that they are still principally or based in the New York office, even though they don't live here anymore. And we see that happen a lot. There's a lot of businesses that have offices in New York, do not have offices in the state, and maybe not even in any other state.
Right, we have,
and the non-resident is wondering, why am I'm working, in Illinois. Why am I paying tax on these wages to New York? It's the work at home rule, the convenience of the employee test, that we discussed earlier.
we could talk about this stuff for hours, but we have about 30 seconds left.
We have about 1 minute left, and I want to close out with this last final question. And it's really based on everything you said is complicated, and it seems like it's continuing to evolve, which is clear. So what suggestions do you have for business owners and leaders within organizations to help them stay ahead of all of these issues and help reduce the impact that the pandemic may be having on their overall state and local tax liability?
I think you need to revisit your business footprint, essentially. And you could add to that, Rich. You need to look where you...
I think you really need to, you need to revisit, if you haven't done Nexus studies to begin with, you should do them. Because you may have outstanding exposures out there that you don't know about. And I would assume that the states are going to be more aggressive about collecting their taxes as they're struggling to finance their budgets in this situation. If you do have old Nexus studies, have they been updated even just to recognize that what used to be cost of performance in many states is now market-based sourcing? Maybe you're misallocating those. Take a look. Do you know where your telecommuters are? Are they going to be staying there after the emergency is over? Are you aware of the policies in each particular state where you have a telecommuter? Because you may end up having exposure. So it's really a question of revisiting Nexus, period, revisiting Nexus during COVID and after. So sort of a three-part process. And apportionment, and
listen to all the 50 governors' press conferences every day for tidbits and clues as to how things are going to be handled.
So I think 2020 is going to be really tricky. And by the way, if you haven't done Nexus studies or apportionment studies, then all this is beside the point. You probably want to do that even if there wasn't a COVID-19 emergency. But this webinar is about the COVID-19 emergency.
Well, gentlemen, thank you so much for your time and your insights and your expertise. We very much appreciate it. To everyone who joined us today, if you have any additional questions, again, please reach out to your Berdon advisor if you're a client, or Rich or Wayne will also be sending a follow-up email, so you could contact us through that. Where we'll have a link to the recording of this webinar so you could have it. And then, as we mentioned, part 1 and part 2 will also be available on our website sometime next week. So please check that out. We hope everyone continues to stay safe as we begin to reopen all of our cities and states, and enjoy your day and summer. Thank you all very much for your time.
Thanks, everybody.
Thank you.